Banking Law, Unit 3. So, the Unit 3 of Banking Law speaks about the relationship between banker and customer. So, let's define banker. Who is a banker? A banker is one who, in ordinary course of business, honors checks drawn upon him by persons for whom he receives money on current accounts. So, banker is a person who deposits money of his customer and he honors checks of that customer. Then he is a banker. In the case R. Pillai versus Yesaya, a money lender who doesn't accept a deposit and checks is not a banker. So to be a banker, he should accept a deposit from his customer and he should give him a check. He should honor his checks. Customer. Who is a customer? The one who has either a current or a deposit account, or in absence of it, some relationship with the bank in ordinary course of business. That can be seen as banking business. So any person who has his bank account in the bank or he has deposited his money in the bank, he is a customer of that bank. In the case Central Bank of India versus Gopinathan Nair, it was held that a person whose money has been accepted by banker on footing that he will honor up to the amount standing to his credit is a customer. So if a banker accepts money from a person, then he automatically becomes his customer. Relationship between banker and customer. The first relation is of relation of a debtor and creditor. So when the person deposits some money in a bank account, the customer becomes a creditor, and when the bank accepts the deposit of that customer, the banker becomes creditor, the debtor. But when the bank gives a loan to his customer, the banker becomes the creditor, and when customer accepts the loan, he becomes the debtor. That is, he owes money to bank. So there is a relation of a debtor and creditor, and both customer and bank can be debtor or either be debtor or creditors. Then we have banker as an agent of customer. So if a banker performing a function of an agent to his customer, then he acts as an agent. He can perform the functions of buying or selling of securities on behalf of a customer. So he can either buy or sell securities on behalf of his customer, then he acts as an agent. If he is collecting checks, dividends, bills or promissory notes on behalf of customer, then he is acting as an agent of that customer. Then banker as a trustee. A bank can act as a trustee to his customer. So he can act as a trustee when appointed as a receiver of a partition between members of JFP. So if he is appointed as a receiver by the court to partition between the joint family property, then he acts as a trustee. Then if he receives money for specific purpose, then at that time he acts as a trustee. Then if money is paid with special instructions, if the customer gives him money with special instruction, then the banker acts as a trustee at that time. The next relation is a banker as a bailee. So if a banker, when does a banker act as a bailee? When the banker's locker facility is used. So when the customer deposits his valuables in the locker of the bank, then the banker acts as a bailee to that customer for safekeeping of that valuables. Then if a banker accepts the valuables, the locker facility without fees, then it is a gratuitous bailee. But if he does this with fees, then he is called a bailee for reward. The next relation we have is a banker as a privileged debtor. So any money that is deposited in the bank, the banker has a privilege to give it to loan to another person or spend it anywhere else. So these are the relationship between a banker and customer. The next important question is rights of a banker. So what are the rights of a banker? The first right is the right of a general lien. So in a general lien, he can hold security. So lien is nothing but a holding of a security. If he is giving loan, then he can take a security from the person who is taking the loan and keep with him. It is called a lien. So he has the right of a general lien. He can hold a security. The next right is a right of the set-off. So if a customer has more than one account in that bank, then he has a right to combine both of those accounts. If one account has a credit balance and the other account has a debit balance, to match it off, to pay off his credits, the bank can combine both of his accounts and pay his debt. Then the banker's right of appropriation. So without specific instruction, bank may use a deposit to pay any loan. So for example, when if a person is having more than one loan in a banking institution, and he deposits his money but doesn't specify which loan to be fulfilled, so the banker is on his own discretion can fill up any loan he wants. So this is called a banker's right of appropriation. But if the customer specifies which loan to be filled, then the banker has to fill only that loan. The next is right to charge interest and commission. So the banker has a right to charge interest on deposits and take commission for his service. Then right to close the account. So the banker has the right to close the account by giving notice to customer. He should compulsorily give notice to customer for that. Case law. Garnett versus McCarvan. In this case, he opened accounts in two different branches. One account was with which he was taken loan, and in another branch he started depositing money. So the bank they combined both his accounts and paid off his debt. It was held as valid appropriation. The next important concept is obligations or duties of a banker. So what are the obligations of a banker or duties of a banker? Duty to honor customers' check. He should honor customers' check. It is a duty upon him. Then duty to maintain secrecy of a customer's accounts. Duty to maintain a proper records of customer. Then duty to follow customers' instructions. Then duty to give notice before closing the account. These are his duties. Only two of them are important in this. Duty to honor customers' check and duty to maintain a secrecy of customers' accounts. Both see one by one. Duty of a banker to honor customers' checks. So it is an obligation to honor checks having sufficient funds according to section 31 of a Negotiable Instrument Act 1881. So if the customer is having sufficient fund in his account, then it is the obligation of a banker to honor that check. He cannot dishonor that check, he cannot reject that check. Then extension of statutory obligations by agreement if no funds overdraft facility. So even if the customer doesn't have fund but he has an overdraft facility with the banker, then he should honor that check upon the agreement. Then overdraft arrangement is a contract. So this overdraft arrangement he does with the banker, it is a contract. So bank can't terminate without notice. So bank can't terminate this overdraft facility of the customer without giving a notice to customer. Overdraft is a loan repayable with interest. So any check with that honors that is honored by the bank on overdraft, that overdraft is a loan given by a banker to his customer on whose check is honored. So the customer should pay this loan with interest. Bankers to have reasonable time for crediting funds. So whenever check is given to the banker, then he can take it a reasonable time before crediting funds. The next is effects not cleared. If the check is returned due to effects not cleared, then he should return it with the notice that effects are not cleared on the check. Consequence of a wrongful dishonor. So if there is a wrongful dishonor by banker of the check, then he should compensate that customer. In the case of Gopesh Chandra Pal versus Nimral Kumar Das Gupta, it was held that the remedy for check dishonor lies in a civil court, so it is not criminal. Liability to return the dishonored check to customer. So if the check is dishonored, he should return it back to the customer. So in the case of Syndicate Bank versus Swaika Chemical Works, it was held that you should either return it or give him an intimation that his check has been dishonored. The next important concept is banker's obligation to maintain secrecy of customers' accounts. So what is this? Secrecy of customer's account, not disclose condition of a customer's account unless a reasonable and a proper occasion. So the banker should not disclose his customer's information to anyone unless if there is a reasonable and a proper occasion. So when disclosure is justified, so when is this a reasonable and proper occasion when a banker can give information to any other person of his customer? If a customer gives a bank as a reference, if the customer himself has given someone that the bank is a reference and ask him about information, then the banker can give information. Then the customer introduces a proposed guarantor to his bank. So if a customer proposes a guarantor to his bank, then the bank can disclose the customer's information to that guarantor. Then by order of a court, so if they have to obey the order of a court and give information. Then a public duty to disclose. So if there is a danger of treason to state by that customer, then it becomes a public duty of that banker to disclose his secrets. Then protection of bankers' own interests legally requires it. So to protect the banker's own interest or to protect the bank, then he can disclose it to if it is legally required. Then by civil court during inspection. So if a civil court orders inspection on that customer, then the banker is obliged to give the details of that customer to civil court. In the case Katta Bowman Transport Corporation Limited versus SBI, so this maintaining secrecy of banker of customer's account is a legal duty and it is not just a moral duty. The next important concept is special customers of a bank. So who are the special customers of a bank? Minor. So anyone who is below 18 years of age is a minor. So according to section 26 of a Negotiable Instrument Act, minor may draw, endorse or deliver and negotiate instruments. So he can open a bank account. But only rights of that bank account are transferred to him. The liabilities are not transferred to the minor. The next is illiterate person. So the illiterate person can give the thumb impression instead of signature and he can open his bank account. And if he wants to draw money, then he should personally go there to take money. Then a lunatic person. A lunatic person cannot open bank account. Then a married woman. So if any married woman opens a bank account, husband is not liable for her debts. Then a Pardanashin woman. So a Pardanashin woman is a woman who does a parda or veil or wears a hijab. So she should open her by her free will. The banker should take a precaution that the Pardanashin woman is opening bank account out of her own free will. Then joint account. All person sign and they can assign a nominee. So in a joint account, all person of a joint account should take signatures and they can even hire a nominee on whose name the account will go. The payment will be done. Then partnership firm. So partnership firm can open a bank account. Then joint stock companies. So if the company should be registered under Indian Companies Act 1956. Then they can open a bank account. In the case of Mohari Bibi versus Damodar Ghosh, it was held that a minor can enter into a contract for supplying necessaries to him. The next is consumer protection. So it is governed by the Consumer Protection Act 1986, Section 2, Clause 1D. So consumer includes a person who avails or hires a service for consideration. So any person is a customer if he avails a service for consideration. So hence a bank is a customer of a bank if he owns account in that bank. So since he is a customer of a bank, he can file complaint under this act for deficiency regarding unfair practice of the bank. So this concludes the third unit. Thanks for watching.